Good morning. My clock has 11 o'clock on the laptop, so welcome to a session of oral argument before the 5th DCA. I am Judge Lambert. I'll be presiding over this oral argument this morning. On the panel with me today, you see on the screen, is Judges Wallace and Eisnagel. We have one case this morning, 11 o'clock. It's case number 21-1000, Kidwell Group, LLC, etc. versus American Integrity Insurance Company of Florida. It's a civil case. You see on the clock, each side will have 20 minutes to argue. The clock will have a default time of 5 minutes for rebuttal for the appellant. Mr. Barr, if you want some other different time for rebuttal, let me know, and I'll tell the deputy clerk to make the change on the clock. The yellow light should come on when you get into your 5 minutes. Obviously, you can keep going if you want, or you can stop. It's up to you. If you don't see it, I'll remind you. Just for the benefit of we are being live streamed on YouTube, so keep that in mind with any of your comments. Also, if you have any type of electronic devices, please put those either in the off mode or the mute mode so that they don't interfere with either your presentation or with your opposing counsel or with the courts. That being said, counsel, if you're prepared to go, you may proceed.
Thank you, Judge. Good morning. May it please the court. My name is Chad Barr, and I represent the appellant in this case. I'm just going to refer to them for the court's convenience as air quality assessors, or maybe air quality. I'd like to reserve 5 minutes of my time for rebuttal, if that's okay.
Mm-hmm.
Your Honors, first of all, I just wanted to say thank you for allowing me to reschedule this. I'm unfortunately had to have oral argument in the 11th Circuit last week, so I appreciate you being flexible with rescheduling this.
No problem.
That being said, there's two orders that we're asking the court in this case to reverse. The first is an order dismissing air quality's complaint with prejudice, and the second order is an order striking the air quality's claim for attorney's fees pursuant to 627.428. So really this case boils down to two issues, and the first issue
was this what was assigned here? What were post-loss benefits assigned?
Yes, there was a post-loss assignment of benefits in this case executed by the insureds in favor of air quality assessors.
Okay, what was the benefit assigned? If an assessment is not a service to protect, repair, restore, or replace property, or to mitigate against further damage, what benefit was assigned here? If that's not the case, if those are two different things, what's the benefit, the post-loss benefit being assigned under the policy? Well,
the benefit being signed is the part of the home insurance benefits necessary to pay for the services. Okay, so when we're talking about benefits, we're talking about the
right.
payment.
But why is it? But no, counsel. Why is it covered under the policy if it's not related to protection, repair, restoration, or replacing property or mitigation of damage? How is this assessment covered?
Okay, so first of all, that requires us to get into the policy and what the policy says that the policy will cover. So generally, the policy is going to cover necessary services related to a loss. So the policy generally, and we don't have the policy in this case in the record, but generally the policy is going to be a broad scope of coverage, anything that's necessary related to a loss. This statute is more specific. This statute is talking about specific services that our opinion and our argument and our allegations and our assignment of benefits all say the scope of our services do not fall within the scope of the services set forth in 715.
Right, but that's the question, right, counsel? Is in order to repair or restore or replace or protect or mitigate, don't you have to go in and look at what the damage is and assess the damage first? I mean, how is it not just a necessary subset of those words?
I think you said an important word there, and I think the important word is a lot of times the beginning stage of all this work is an assessment. So you got to go in and if we're trying to figure out where is the water coming from, okay, that's not work defined under 6277152. Those services might be used by somebody else, or they may not be. In this case, there's no evidence that air quality's assessment report was used by anyone else to swing a hammer, put up a wall, take out.
Right, but I don't know that the statute doesn't say it has to be used. the question is if it's not in order to protect, repair, restore, replace, or mitigate, then
It
what?
can
Well, then
still be-
what is it for? What? It's not just an assessment for fun, right? What is the assessment for?
Well, the assessment is for whatever purpose that the secondary provider needs to use that for, if they need to use it at all. So if they come in and they say,
Well, I'm asking you what was the purpose of the assessment here? Was it to assess post loss? Was it related to post loss benefits?
but that is the question that we don't have the answer to, because that information is not in the record. So we've got a broad scope of an assessment service provided. We don't have the assessment report in the record. We don't know what exact service was provided. We've got a statute that requires very specific services that are or states that very specific services are governed by that statute. And we've got a policy that presumably is going to have a much broader scope of coverage. So these questions that you're asking are all very good questions, but they're questions that are not
Counsel,
appropriate.
can't the trial court look at the assignment itself? Well, I mean,
Yes,
I understand your argument that, hey, there's no report, but the assignment itself, right? I mean, doesn't that have something to say about what happened here and what the assignment is?
It does.
I mean, doesn't the assignment itself define the scope of the assessment?
It does. It says that but it uses the phrase assessment. It doesn't go any further. It's an assessment, it's a visual inspection, and it's the preparation of an engineering report.
But looking for what, counsel?
That is the question. And that is the question that's going to be found within the.
Was it just an open-ended assessment, or was the assessment looking for some kind of damage?
Well, the assessment, it could have been looking for damage. It could have been looking for the source of the water intrusion. It could have been looking for the presence of mold on the property. But none of that is designed for air quality to come in and actually swing a hammer, put up a wall, take out baseboards. And so those are all questions that may be appropriate for a summary judgment proceeding, but not for a motion to dismiss. There's lots of questions, and you're asking great questions, but that's all information.
I still don't understand why that is not a necessary sort of subset of the language the legislature put into the statute: services to protect, repair, restore, or replace property or mitigate against further damage. I mean, there's an argument you can't do any of that stuff without assessing.
Well, I mean, yes, but generally, that's if you're talking about the folks that are coming in and swinging the hammers, they're making an assessment on what needs to actually be replaced. We don't know what's contained within the scope of this assessment. In this case, the court just made an open-ended determination that any service with respect to an insurance claim is within the scope of 627.7152. And I think if the legislature had intended that every service provided with respect to a home insurance claim to be covered by that statute, it would have said so. But it didn't. It laid out very specific parameters for what services are covered by 627.7152.
And I guess the question becomes is simply right. You're absolutely right. I mean, there is some, merit to your argument that, look, the word assessment isn't in there, right? I mean, that's your argument, and there's some appeal to that. But what I'm trying to figure out is, why isn't assessment of damage to the property in a post-loss benefits context, right? Why is that not necessarily when we look at the actual written assignment itself, which we've already established defines the scope of the assignment? Why isn't that a necessary subset of the language: services to protect, repair, restore, or replace property, or to mitigate against further damage?
If you look at, what I did was I took in my brief and I laid out all the subsets of the statute that talk about what this looks like in real time. And it all talks about the work being performed. And so what does the work being performed mean? And so, you can look at that, and a lot of that stuff, when we're talking about work being performed, it's not stuff that an assessor is going to be doing. There's not going to be the date the permits are pulled. There's not going to be the date that the hammers are being swung. They literally are just coming in and figuring out, where's the water coming from? Is there mold present on the property? And then work is being done with respect to that, or potentially not. And so our opinion is that the statute was drafted the way it was to govern very specific services. And if they wanted it to say every service is governed by this statute, it would have said that, but it didn't. It's very specific, and it would have been very easy for the legislature to say any service provided with respect to an assignment of benefits after a covered loss.
Give me just one theoretical example of where an assessment would be covered, but would not be related to services to protect, repair, restore, or replace property. Just help me work through it.
If the provider is not the one swinging the hammer, putting up the wall, tearing out the baseboards, then that service is not work performed pursuant to 627.7152. So if someone's coming in and providing an engineering report, if you go through the brief and you see all the things where it talks about work and the deadlines and the requirements that are in place with respect to that, then what you're going to see is there's no way that an assessor or an engineering report can comply with any of that stuff, because it's not work. It's not work being done. It's simply an assessment, visual inspection, testing, and that's it.
So you're saying that the definition of work excludes an assessment?
Based on the way that the legislature is employing that term within all the different provisions of 627.7152, yes, if they're not the one swinging the hammer or putting up the wall or tearing out the baseboards, then that's not work.
Can you just point me to what language specifically you're referring to? Because it seems like on some level, when you go out to a property, you mobilize, you take your equipment, you assess, even if you don't take equipment, it seems like, at least in some ways, that's work. You're working, right? You're doing work. It's just not that you're not putting up a building, but you're working.
So for instance, and I've laid these out on pages 15, 16, 17 of the brief, but for instance, section 2A4 requires the assignment agreement to contain a written itemized per unit cost estimate of the services to be performed by the assignee. It's a test. It's a test that has a prefixed rate assigned to it, and there's no. You're talking about 2A4?
Yes, Judge. Well, that's a requirement for the agreement itself. That doesn't define the assignment agreement.
Well, but
that's once you have an assignment agreement, that's what is required to be in it, right?
And there's no way that an assessment, what I'm trying to say is there's no way that an assessment can comply with that particular provision, because there is no per unit cost estimate of the services to be performed by the assignee.
Because you're not selling a unit.
Correct. There's no items. There's no tangible goods that are being installed, hammered in, put up, that kind of a thing.
So by definition, you're saying because it says per unit cost, then that means, and since you're saying, look, an assessment doesn't have any physical units, maybe time units, but not physical things, right? Is that what you're saying? Correct. Therefore, this statute could not apply to sort of what happened here.
Correct. And I just think more broadly, if the legislature wanted it to apply to every service provided with respect to homeowner's claim, it would have said that. And we have to consider why the court used those specific terms.
But I think that argument is a little too broad. I mean, I think you have to convince us that it doesn't fall on one level. One of the things you have to convince us of is that it doesn't fall within services to protect, repair, restore, and replace, right? The very broad argument, well, they could have said everything, doesn't necessarily get you there, because we do have some very specific statements. And the question is does this fall within any of those? Do you agree?
That was a very long question, and I apologize. I was trying to follow you all the way through, and then do you agree at the end was a little bit difficult for me to say whether I agree, and I apologize for that. But essentially, the statute is not ambiguous. The statute is very clear. We have to interpret it based on the plain language. It says those specific things. The assignment says that the services are not for protect, repair, replace, mitigate. A complaint says that it's not to repair, replace, protect, or mitigate.
But those are conclusory statements, though, counsel, right? I mean, do we look at the conclusory statements, or do we look more at the substance of the assignment itself, of the scope of what's going to happen?
Well, I think there certainly is a question regarding whether an assessment falls within the scope of 627.7152, and that's the argument with respect to point one. I've just got a couple of minutes left, and I just want to touch on the Menendez issue. And I think that what we have to do is we have to first consider the trial court found that Menendez did not apply. finding that the relevant date in the statute was the date that the assignment of benefits is executed. And this is plainly wrong. The date, Florida law is clear that the relevant date for purposes of determining whether a statute applies is the date that the insurance policy was issued. This court addressed this exact issue in FIGA versus Johnson. And in that case, the statute was the anti-stacking statute, and it concerned the date of any automobile accidents. And this court found that the relevant date is not the date of the automobile accident. The relevant date is the date that the insurance policy was issued. So in this case, the policy was clearly issued before the statute was enacted. So the trial court was wrong in finding that Menendez did not apply. So because Menendez does apply, because the statute was enacted after the policy was issued, we have to go through the Menendez analysis. So the first question is there a clearly expressed legislative intent that this statute apply retroactively? The short and simple answer is absolutely not. The statute does state that it concerns assignments of benefits issued after a certain date, but it's silent as to whether or not it affects any policies issued after a certain date. But even if there is a clear expressive intent of retroactive application, it simply doesn't pass the constitutional analysis set forth in Menendez. And there's yes, Judge.
Mr. Barr, going back to the motion to dismiss issue, from the hearing or from the order that the court issued specifically with regard to the motion to dismiss, what is it that you believe the court relied upon outside the four corners of the complaint to render its ruling on the motion to dismiss?
Well, my answer to that is two-part. First of all, the court couldn't have considered anything outside of the complaint, but more importantly, the court, I believe, assigned evidentiary value to the argument of the defendant's attorney at the hearing, one, and two, I believe the court just basically announced a broad proposition that any services provided with respect to a homeowner's claim is covered by 627-7152 when that language is not present in the statute.
And assuming, I'm assuming that you're assuming, or maybe not, getting to this point where there was an assignment of benefits, was there already a determination from the insurance company that there was actual liability for the loss, or was that part of the assessment to determine exactly what was covered? I understand that the triggering event was a storm, but specifically with regard to the damage, was there any type of determination of liability or exclusion of liability?
We don't have any of that information. I don't have any of that information. It's certainly not in the record. So I would assume that there was coverage, but I don't know. This was sometime after the loss that the assignment was actually assigned. So I don't have the answer to that question. It's not in the record.
Okay, counsel, you have 3:33. So,
thank you. I'll reserve the rest of that time. Thank you.
Okay, very well. Okay, Ms. Fernandez, if you're ready, you can proceed.
Thank you, Your Honor. May it please the court. My name is Kim Fernandez, and I represent the appellee insurance company, in this case, American Integrity. 2 points I want to make is that there are no disputed issues of fact that would preclude the dismissal that occurred, and that the statute has not been applied retroactively. I'd like to return a minute to the facts that have already been discussed to point out that this isn't a situation where this company, the appellant, used one of its old AOB forms after the new law had applied, perhaps in ignorance of the new law because it was just used an old form. This is actually
Ms. Fernandez, if you take the wording in the assignment on its face that is not meant to protect, repair, restore, or replace damaged property or to mitigate, isn't that in and of itself, taking the plain meaning of those words, isn't that a disputed issue of fact for purposes of this litigation?
Respectfully, Your Honor, not when the same document contradicts those terms. For instance, the document itself says that it is a contract for services and that it has a scope of work and of price. However, the work and the price are not listed in there. The document also says that the agreement's being made in consideration of labor services, and or materials. It also says that unless additional work or upgrades are requested, the parties agree, blah, blah, blah. And so those terms seem to are contradictory to the bald statement that this is in no way meant to protect, repair, restore, or replace. That statement that Your Honor refers to was created in this document post enactment of the statute in an effort to create an animal, to create a thing that would never be subject to this law.
Counsel, does the assignment have enough in it to even make this determination? I think part of what opposing counsel's argument is look, there just wasn't enough before the trial court to make this determination properly at the dismissal stage.
And Your Honor, there was enough for a dismissal to be rightfully ordered, partially because all of the questions posed to my opposing counsel have indicated that where was the proper statement of a claim? Where was the definition of the damages that would be owed to the appellant? What was done? If it wasn't work, what was it? This is all a failure to state a claim upon which benefits could be granted. And it's all orchestrated to, again, circumvent a law. It's not a catch up. It's not, from here on out, we understand there's a lot of pushback here and we're going to follow the law. This is an indication and this is an inference that the lower court took, which this court can abide by, that this entity intends to continue doing what they're doing, however they want to define it, by definitely defining it as not subject to the new statute and never will be.
Ms. Fernandez, doesn't that assume also that you have other situations where the policy has been entered into or is effective prior to the effective date of this statute? You're acting like it's broad brush, it's going to apply in every case. And really, we're talking about a situation where, the policy is entered into before the statute is effective. So that would limit what I believe you're alluding to, which is this overbroad application of the appellant's position. Is that true?
No, because this suit is not about the terms of the policy, as evidenced by the fact that the policy.
Well, that's contrary to what the case law says. You would agree?
I would not agree, Your Honor. Are you referring to the case law that was referred to with Menendez earlier, saying that it has to do with when the insurance policy was entered into as opposed to anything else?
Did Menendez talk about assessments?
No.
That was front and center. No?
No. And since Menendez was raised, I would urge the court to review one of the few federal opinions that has come out, which gives a discussion of the distinction between Menendez and the situation that we have here. The case is cited in our answer brief, but just for your purposes for reference, it's SFR Services versus Indian Harbor Insurance. That case says the focus must be the date on which the assignment was executed, not the date on which the insurance policy was issued. The reason is that subsection 2, which was already discussed in my opposing counsel's argument, poses procedural requirements for assignment of benefits to be valid and enforceable. Those requirements only affect rights under the assignment of benefits, not substantial rights under the insurance policy, which vested upon the insured and the insurer's execution of the insurance policy agreement. So it's the date of the AOB contract itself that should be the determining factor of the application of the law. And that is the explicit language in the statute as well at subsection 13 of the statute, which
Counsel,
says, yes.
Counsel, I appreciate your argument on the retroactive application. I'm interested to hear what sort of going to the first issue, sort of before we get to that. It seems like there's two questions. One is, by its own language, would 627.7152 apply here to an assessment where, as opposing counsel says, they're not swinging hammers, and there's at least some merit to the argument. Hey, look, there's not really a per unit cost here. How could they comply with the statute that says you have to give a per unit cost, what would that be? And then the second question is if this does apply, do we even have enough information? Again, I'll ask you, I don't know that I got a clear answer. Is there even enough information before the trial court to make the determination?
Just to clarify, Your Honor, to make the determination of the dismissal, to make the determination that okay, thank you.
That the statute applies and therefore that the claim is barred or whatever, and therefore dismissed, right? So, under its plain language, does the statute apply here when there's no per unit cost, no hammer being swung, right? And then number two, even if it theoretically does, do we have enough information to decide it at this point?
Okay, let me start with the word assessment as defining what the appellant does versus the statutory language, which does not include the word assessment. The court needs to consider the fact that those terms were used by plaintiff post enactment of the statute so that they were able to.
I think you're misunderstanding. I'm looking at the statute that your opposing counsel pointed to, 2A4, requires an assignment agreement. It says an assignment agreement must do all these things. One of those things is contain a written itemized per unit cost estimate of the services to be performed. Your opposing counsel says, look, there's no way when there's just an assessment, we're not swinging hammers. There's no way to give a per unit cost because there's no unit cost, right? What do you say to that argument? That's in the statute.
Okay, Your Honor. That portion of the statute itself was written in there to give notice ahead of time as to what was going to be done and what it was going to cost, most importantly. That's the reason, right? We know from Exhibit A to the complaint that this assessment cost $3,500.
Right.
But
what's the per unit cost, right? I mean, what would they have put, had they complied with the statute and given the notice? What would the per unit cost estimate have been? What would they have? What are the widgets that they're going to estimate the cost of, right?
Putting myself into the shoes of the appellant, I would assume that they would put engineering assessment and report $3,500.
So the per unit cost, the unit in that sense would be the report.
That's
the
all
cost of the report.
That's all that they've provided and prepared according to the record. I know that the report itself is not in the record.
Your argument is that the per unit cost doesn't have to be a widget. In other words, that it doesn't have to be something physical. It can be it doesn't have to be a nail.
Understood, Your Honor. A line item cost estimate actually includes services as well as widgets. So it can include the lumber and the nails, but it's also going to include the build, the tear out, the services.
But counsel's arguing that per unit necessarily means nails, lumber, things like that.
I disagree.
You think it can also be a report or time or something, or?
That's certainly the benefit that they're asserting they're giving to their client, the homeowner, under the policy. That's the benefit they're providing is an engineering report. So why would that not be a line item with a cost?
Let's say for a moment that this panel ended up agreeing with you on that point. Why is there enough in the record here to dismiss?
Okay, rather than
how do we even know what happened without making assumptions?
Because in application of the law, which is of course what we're arguing, the plain document itself, the AOB, obviously does not comply with all of the requirements of the statute, yet it is dated well after the statute was enacted. And the statute explicitly says that this statute, which is entitled Assignment Agreements, applies to an assignment agreement executed on or after July 1, 2019. No indication.
It's only an assignment, but it's only, their argument is, look, it's only an assignment agreement if it's providing services to, quote, protect, repair, restore, or replace property or to mitigate against further damage. They're saying, look, this is an assignment agreement, but it doesn't do any of those things. Therefore, the statute 627.7152 doesn't apply, right? So
Correct.
don't you have to convince us that, hey, this assignment did protect, repair, restore, or replace the property?
Well, the burden is on them, but yes, with regard to protect, restore, repair, replace the property, the argument being made by the appellant regarding what they did was that they were a conduit, that their report would be given to the hammers and the nails and the folks who use them, and it would guide them in what they needed to do. And so, as Your Honor, the point Your Honor made at the very beginning of this argument, how could that hammer and nail work without a prior assessment being done? And if the assessment is pivotal and necessary, a necessary part, then it falls under the statutory terms.
Yeah, I think counsel's saying, look, that might be a very logical sort of line of thinking, but that's unproven thus far in the record. I think is I think counsel's point.
Mm-hmm. And my point is that the statute didn't fail to address the unicorn that is the appellant's work. The appellant's contract was written to write itself around the statute itself. Cart before the horse kind of thing. It's not that the legislature ever contemplated, well, there could be services, but we don't want to include those in here, so we're going to leave that word out. It's the fact that the contract itself, which is the AOB contract, was written after the statute was enacted. And how do we know that? Because it tracks the language of the statute. And then the initial brief arguing how the two don't apply to each other states all of the items that are listed in the statute which don't exist in the AOB. Of course, they don't exist in the AOB. The AOB was written to avoid regulation. The statute was written. Yes.
Ms. Fernandez, you've referenced the report now in your argument, and we're talking about the services performed. You would agree that the report would probably be, in addition to the AOB, the evidence of the services rendered by the appellant. Is that correct?
Your Honor, I'm actually relying on the invoice attached to the complaint itself as an exhibit.
I understand that. But the report would be the invoice is just documenting the time put forth in creating the report. The report's the actual detail as far as what type of services were rendered, correct?
I believe so. Okay,
and the report had not been part of the record at the time the trial court made the ruling on the motion to dismiss. Is that correct? Neither party put it in.
Correct.
So why isn't that in and of itself evidence the trial court went beyond the four corners of the complaint in rendering a decision in the motion to dismiss?
Because the appellant would be seeking payment under their invoice, regardless of what the report says. Regardless of what, even if the report says we went on site and found absolutely no damages to the property, even if the report said we went on site and the house was a mess and it was all because the homeowner was a slob, it had nothing to do with the
Counsel,
storm.
how do we, I mean, you may well be right about that, but how do we know that based on this record?
By virtue of the fact that the only pivotal documents presented to the court with the complaint to justify their claim was their contract with the insured, giving them the standing to come under the policy, and the invoice indicating that they should be entitled to $3,500 for preparing an engineering report. The contents of the report.
I think one of your opposing counsel's stronger arguments is look, maybe this is a summary judgment case, but he says, look, it's not a motion to dismiss case, right?
Mm-hmm.
So point us to the what is insufficient, right? What about strictly from a motion to dismiss standpoint, can you look at the complaint and its attachments and establish that what they did was services to protect, repair, restore, or replace the property? And if you can, be specific.
Yes, Your Honor. On page 12 of the record, the complaint says that the plaintiff provided reasonable and necessary assessment services. Anything that's going to be reasonable and is going to be necessary under the claim should be falling under the policy and therefore the statute. Those
But we
reasonable
don't,
and
do we have,
necessary.
was the policy attached to the complaint?
No, Your Honor, they say in their complaint that they don't have a copy of it.
Well, I mean, is that a problem for your case here? I mean, can the trial court consider the policy if it's not attached to the complaint at the dismissal stage?
Nothing can be considered by the court that's not attached at the dismissal stage.
Right.
And
So, but you referenced the policy, and I'm just sort of saying, well, what do we do with that? Because that wasn't attached to the complaint.
okay, policy was my word. It was not the word in the complaint. Originally, you asked me to cite to what they state in the complaint that would not surpass or survive a dismissal. And I was stating that they say in the complaint that they provide reasonable and necessary assessment services relating to the loss. They say that they are seeking an extension and or modification of existing law, which I don't understand how a remedy could be formulated for that under this statement of claim. And then attached to their requests for that are the AOB contract itself, which I have cited to all of the references in their contract, claiming to include work and price and labor and services and materials and additional work or upgrades as requested. That is their establishment of everything that they are asserting that they have done and should be paid to do. And that it's okay that their documentation doesn't match the AOB law in effect prior to when they entered into those contractual documents.
Can you separate assessment for a loss from protect, repair, restore, or replace property or to mitigate against further damage? Can those two things be separated?
Well, Your Honor previously stated for the purposes of argument that they can't be, that they seem to be one and the same. You can't put on a blindfold and go put on a new roof just because somebody tells you to. You've got to go assess that roof and determine whether it's repairable versus must be replaced.
Well, don't mistake my question to opposing counsel as a statement of the law. It was a question, right? So I'm asking you the same question. Can they be separated? Is there a circumstance where is it possible for them to be separated?
I'm sorry that I don't really understand your question as far as separated. If you mean separated in terms of line items of things provided to a homeowner for their benefit.
Could there be coverage for assessments that aren't intended to lead to repairing or restoring?
Okay. My answer to that would be no. But in order to back that answer up to you, I would probably need to cite to policy language, which is not a part of the record.
So why doesn't that, how do you get around that though again? So we're back to, the policy is not in there. So the policy wasn't attached to the complaint. How do you get around that?
By virtue of the fact that an assignment of benefits was submitted as the basis for their complaint. And the statute says that an assignment agreement that doesn't comply with this subsection of the law is invalid and unenforceable. If it doesn't match the law, it's invalid and unenforceable. Therefore, there's nothing to stand on for the complaint. It must be dismissed.
But theoretically, the policy, and I can't imagine there's a policy out there that says this, but we don't know. Theoretically, the policy could say, hey, there's coverage for any time you want to assess if there's any damage.
Okay.
Up to once a month, go ahead and we'll cover that.
Okay.
And
in your Honor's
that would have nothing to do. That would have nothing to do with protecting, repairing, or restoring, right? I guess arguably anyway. It would just be, hey, we're going to cover, just you're doing due diligence and you want to know, so we're going to cover it, sort of thing.
And once again, here we are trying to define the unicorn that is the appellant's argument. What do they do? What are they?
But we wouldn't have to, counsel, we wouldn't have to try to define it if we had the policy.
And Your Honor, if I agree with that, then the next comment is going to be, and we wouldn't have to do that if we were provided with the engineering report. And we wouldn't have to do that if we were provided with.
Which is what summary judgment's for.
Right.
Understood. But if the contract itself already doesn't comply with the statute, why does there need to be anything else? You've got the
But I think,
statute
well,
and you've
I
got
think-
the document.
Counsel, I think the problem is we keep circling back to in our evaluation. It would be awful helpful to know what the policy says in evaluating whether the statute necessarily applies, right, to the assignment.
Because if the word assessment is nowhere in the policy, it would affect your opinion.
Well, because we don't know what's covered.
Right. So it would
Right.
affect your opinion to know if the word assessment appears anywhere in the policy.
Or if there's some right to an assessment or some coverage for an assessment that is somehow not connected to protecting, repairing, restoring, or replacing the property. I mean, I understand you're sort of probably thinking, well, why would a policy say that? I don't know. I haven't seen every policy, and we haven't seen this one, right?
You're right. You're right. And so we,
All right, Ms. Fernandez, you're past,
you're right.
go ahead.
I was just going to close, Judge. It's okay. Well, I'll stop with the hypotheticals. American Integrity.
Well,
just asked
well,
me-
answer Judge Eisnagel's question and then, well,
It
go ahead
was-
and answer Judge Eisnagel's question if you haven't finished. Okay, and then just wrap up, please.
I did finish, Your Honor, because actually, Judge Lambert, I was going to speak to your comment about the MSJ. But regardless, American Integrity just urges this court to affirm at the motion to dismiss.
Okay, thank you, counsel. All right, Mr. Barr, according to the clock, you have 3:29. I might give you a little extra time since we went over with Ms. Fernandez. So
Thank
go
you.
ahead, sir.
I appreciate it. Thank you, Judge. I just want to just wrap up in conclusion by making sure that the court is well aware of our position as well, that regardless of whether the assessment services are covered by or governed by 6277152, the reality is that the statute doesn't apply retroactively. So what we've heard from Ms. Fernandez, what we've
Why
seen,
wouldn't it apply? I mean, I'm struggling with why we're looking at the policy to determine retroactivity and not the date of the assignment agreement.
well, Judge, this court was very clear in FIGA versus Johnson. The Supreme Court was very clear in Menendez versus Progressive Insurance Company that they specifically stated that in our analysis, we're talking about whether or not a statute is retroactively applied. In our analysis, we look at the date of the insurance policy was issued, not the date the suit was filed or the date the accident occurred, because the statute in effect at the time the insurance contract is executed governs substantive issues arising in connection with that contract. So the issue.
But this is a different contract, though. It seems like this is a different contract altogether, right, than the policy.
The entire claim is governed by the insurance policy. So the assignability of the claim, the coverage of the claim, that's all governed by the insurance policy. And the right to attorney's fees, that's all governed by the insurance policy. So you have the
We don't have
statute.
the policy, counsel.
I'm sorry?
Counsel, we don't have the policy.
That's another valid point, but there is no dispute that the policy was issued well in advance of the statute being enacted. The claim occurred well in advance of
But we don't have any idea if the policy controls assignability because we don't have the policy.
That I would agree with that. I would agree with that statement, Judge.
So isn't your first argument the better one? That look, we don't know if 6277152 applies, and whether this relates to protection, repairing, restoring, or replacing, because we don't have the policy and we don't know what coverage is theoretically out there.
Well, respectfully, I think they're both great arguments, but I do think that the primary issue was put forth first because that is an important question, whether the services are governed by 7152, and we just don't have enough information. There's not enough information in the complaint, in the policy, in the records. The policy is not in the record, so there's not enough information for the court to have determined at the motion to dismiss stage that this case should be dismissed with prejudice, without the ability to reallege, to reclaim, and without respect to what's in the insurance policy. So I would agree with that. Unless the court has any other questions with respect to Menendez or the factual issue, I will concede the rest of my time so that the court can enjoy its lunch. But we would ask the court to both reverse the order dismissing the complaint and the order striking the attorney's fees issues pursuant to the Menendez argument. Oh, you're muted, Judge.
I'm sorry.
Lambert.
I'll unmute myself. Well, I probably am more coherent when I'm muted, but in any event. All right, I will, all right, thank you very much today for your arguments, counsel. Very interesting case. We will stand adjourned and take it under advisement.
Thank you.
Have a good day.
Thank you, your honors.
All right, thank you.